Head Note A. Police custody. Maximum period of 15 days of police custody is meant to be applied to the entire period of investigation, 60 or 90 days, as a whole. Any other interpretation would seriously impair the power of investigation. Head Note B. The words such custody, occurring in Section 167(2) of the CrPC, would include not only a police custody but also that of other investigating agencies. One cannot say that Section 167(2) of the CrPC is applicable to an authority when it comes to arrest but not to custody. One cannot apply Section 167(2) of the CrPC in piecemeal. Authorized officer under the PMLA has power to seek custody. Head Note C. Police custody. Whether the 15 days period of custody in favor of the police should be only within the first 15 days of remand or spanning over the entire period of investigation, 60 or 90 days, as the case may be, as a whole. Issue needs to be put to rest as a legal proposition on an authoritative pronouncement by a larger bench. Head Note D. Remand order. Habeas Corpus. Maintainability. A writ of habeas corpus shall only be issued when the detention is illegal. As a matter of rule, an order of remand by a judicial officer, culminating into a judicial function, cannot be challenged by way of a writ of habeas corpus. It is open to the person aggrieved to seek other statutory remedies. When there is a non-compliance of the mandatory provisions along with a total non-application of mind, there may be a case for entertaining a writ of habeas corpus, and that too by way of a challenge. Head Note E. Notice under Section 41 A CrPC. Whether mandatory. PMLA, 2002 being a sui generis legislation, has its own mechanism in dealing with arrest in the light of its objectives. There is already an exhaustive procedure contemplated under the PMLA, 2002 containing sufficient safeguards in favor of the person arrested. Section 41 of the CrPC has no application at all. Any prior intimation, other than what is mandated under the PMLA, might seriously impair the ongoing investigation. Head Note F. The word custody. Under Section 167(2) of the CrPC, shall mean actual custody. Word custody is different from detention. It can only be physical. When an order is passed granting police custody, any interdiction by any extraneous circumstance or a court order would not kickstart the period of custody. An investigating agency is expected to be given a reasonable freedom to do its part. Admission of the appellant to the hospital of his choice cannot be termed as a physical custody in favor of the respondents. Court permitted the respondents to have custody of the appellant. Head Note G. Arrest. Violation of Section 19 PMLA. Section 167 of the CrPC is also meant to give effect to Section 19 of the PMLA, 2002, and therefore it is for the magistrate to satisfy himself of its due compliance. Any non-compliance of the mandate of Section 19(1) of the PMLA, 2002 would vitiate the very arrest itself.